What would you do if you opened your mailbox tomorrow and found a $30,000 penalty notice from the US government, all because of a small bank account overseas that you completely forgot existed? For thousands of seniors and immigrants, this nightmare is about to become reality in 2026. And the terrifying part is, most of them have no idea it's coming. Picture this for a moment. You're checking your mail, just like any other day, when you see a certified letter from the US government. You open it, expecting nothing more than routine paperwork. But instead, it says you failed to report a foreign bank account. The penalty listed is $30,000. Your US bank accounts are frozen. And if you're a green card holder or applying for citizenship, your immigration case is suddenly at risk. All of this because of a small account overseas you barely use. Maybe one you opened decades ago. Maybe one with just a few $1,000s in it. Now, let me be very clear right from the start. This is not a scary story meant to panic you. This is exactly the kind of situation that is going to become shockingly common under a brand new banking rule taking effect in 2026. And if you are over 60 years old, a green card holder, or someone who was not born a US citizen, this change could affect you far more than you realize. Most people assume that if an account is small, inactive, or back home, it doesn't matter. They assume that because they filed their taxes honestly for years, they're safe. But the rules are changing in a way that removes those assumptions completely. What used to slip by unnoticed will now be flagged automatically. What used to be forgiven as confusion can now trigger penalties, investigations, and immigration complications. The good news is this. If you understand what's coming and you prepare the right way, you can protect yourself entirely. You can avoid penalties, you can avoid audits, and you can avoid problems with your immigration status. By the end of this video, you'll know exactly what this new rule is, why it targets seniors and immigrants, and what simple steps you can take right now to stay safe. So take a breath. You're not in trouble. You're here early, and that puts you in the strongest possible position. Hi, I'm Fernando. For years, I've helped seniors, immigrants, and green card holders make sense of complicated US financial and immigration rules that often feel overwhelming and unfair. I work with people who are retired on fixed incomes, people supporting family members overseas, and people trying to build a secure life in the United States while doing everything the right way. I know how stressful this can feel when you're managing retirement, medical expenses, or immigration paperwork. The last thing you expect is for a forgotten bank account in another country to suddenly become a major legal issue. Most people I speak to are not trying to hide anything. They simply didn't know the rules existed, or they assumed the rules didn't apply to them. That's exactly why this new 2026 banking rule is so dangerous. Not because it targets criminals, but because it catches honest people who never realized they were at risk. And unfortunately, the government is not doing a good job explaining these changes in plain, simple language. Important details are buried in technical documents that most people will never see until it's too late. My goal here is different. I'm not going to use legal jargon. I'm not going to talk down to you. And I'm not here to scare you. I'm here to explain what's changing, why it matters, and how you can protect yourself step by step. Nothing more, nothing less. Over the next several minutes, I'm going to walk you through exactly what this new banking report rule is, who it affects, why seniors and immigrants are being singled out, and what actions you should start taking today, not in 2027 when the first penalties start showing up. If these rules apply to you, you'll know it. And if they don't, you'll have peace of mind knowing exactly where you stand. Because knowledge is protection. And right now, knowing what's coming could save you from a financial and emotional nightmare that is completely avoidable. So let's talk about what is actually changing, because this is where everything begins. Starting with the 2026 calendar year, which means the tax returns and reports you'll file in early 2027. the US government is rolling out what it calls an enhanced foreign account mandatory reporting system. That sounds technical, but the impact is very real and very personal for millions of people. This is not a minor update to an old form. It's a major expansion of how foreign financial accounts are tracked, reported, and enforced. And for the first time, the rules are being applied differently depending on your age and where you were born. Here is the first change you absolutely need to understand. The reporting threshold for foreign bank accounts is being dramatically lowered for specific groups of people. Under the old system, you generally only had to worry about reporting foreign accounts if the combined value of all of them went over $10,000 at any point during the year. For many people, that meant these rules never came up at all. That $10,000 threshold is staying in place for younger people who were born in the United States. But if you are over the age of 60, or if you are not born a U.S. citizen, that threshold drops sharply. In most cases, it drops to just $5,000. And for some people, depending on immigration status or where they are in the citizenship process, it can drop even lower, sometimes to around $3,000. Think about what that really means. An account with a few $1,000s that you've never thought twice about can now trigger mandatory reporting. A small savings account you keep in your home country for emergencies or family visits can suddenly fall under strict scrutiny. Even if you only cross that lower threshold for a single day during the year, the reporting requirement is triggered. And here's the part that surprises most people. This isn't about how much income the account generates. It's not about whether you withdrew money. It's about the highest balance the account reached at any point during the year. So, if you briefly deposited money, sold a small asset, or received a one-time payment that pushed the balance over the limit, that alone can create a reporting obligation. Now, that's only the first change. The second change is just as important, and it's where many people get caught without even realizing it. The definition of what counts as a foreign financial account is being expanded significantly. Under the old rules, most people thought only of basic checking or savings accounts. But under the new system, the net is much wider. Foreign retirement accounts now count. That includes pensions, employer retirement plans, and government retirement benefits held outside the United States. Life insurance policies issued by foreign companies that have any cash value now count. Prepaid debit cards issued by foreign banks count. Digital wallets held with foreign financial institutions count. Even partial ownership interests in foreign property or businesses can count, if those interests generate any kind of financial return or income. In simple terms, if you have any financial connection outside the United States and it has any value at all, there is a strong chance it now falls under these reporting rules. This is especially true for immigrants and seniors who maintained financial ties long before these rules existed, or before they ever imagined they would matter in the US. Many people hear this and think, but that's not really an account. That's just something I've always had. Unfortunately, the new system doesn't care how you think about it. It only cares whether the asset exists, where it's located, and whether its value crosses the new, much lower threshold. And this is where things start to feel overwhelming for people, because when you begin to add up a small pension here, a modest savings account there, and a life insurance policy you haven't looked at in years, you can cross the threshold without ever realizing it. But before you start feeling anxious, there's something even more important you need to understand. Because these changes aren't just about what you're required to report. They're about how the government now finds out when something is missing. And that next change is the one that removes almost all room for error. Here's where this new system truly changes everything. Because for decades, one of the reasons people slipped through the cracks was simple. Government agencies didn't talk to each other very well. Information lived in separate systems. A small account overseas might be reported in one place, partially mentioned in another, or not connected at all. That era is ending completely. Starting in 2026, the IRS, FinCEN, and U.S. Citizenship and Immigration Services are implementing full, real-time data sharing. In plain English, that means every piece of foreign financial information you report is automatically cross-checked across multiple federal agencies. If something appears in one system but not another, the computer flags it instantly. There is no human judgment call first. There is no, "this seems minor." The system simply generates a notice. So, if a foreign bank reports an account linked to you, but that account doesn't appear on your tax return or foreign account reports, it's detected. If you answer no to a foreign account question on your tax return, but FinCEN has data showing otherwise, that inconsistency is flagged. If USCIS is reviewing your immigration file and sees unresolved financial compliance issues, they see that immediately, without requesting anything from you first. This is what makes the new rules so unforgiving. It's not that penalties are new, it's that mistakes are now far more likely to be discovered automatically. There is almost no room left for something to be overlooked, simply because it seemed too small or too old to matter. And as part of this same shift, the government is eliminating most of the exemptions people relied on in the past. Under the old rules, some accounts didn't need to be reported if they were inactive. Some jointly held family accounts fell into gray areas. Some people assumed that accounts opened decades ago, or accounts used only once a year, didn't really count. Those assumptions no longer apply. Under the new system, if you meet the age or citizenship criteria, and you have a foreign financial connection above the new lower threshold, you must report it. It does not matter how often you use it. It does not matter who else is on the account. It does not matter how long ago it was opened. If it exists, it must be disclosed. Period. Now, at this point, almost everyone asks the same question. Why seniors? Why immigrants? Why create stricter rules for certain groups of people? According to government studies conducted over the past several years, seniors over 60 and immigrants are statistically the most likely groups to have unreported foreign financial accounts. Not because they're doing anything wrong, but because their lives are more likely to span multiple countries. Seniors often worked overseas, retired abroad for periods of time, or maintained accounts in other countries long before these reporting rules existed. Many simply never realized U.S. law requires reporting worldwide financial assets, no matter how small or how old. Immigrants face the same issue for different reasons. Millions of people who move to the United States keep financial ties to their home countries. They support parents. They hold on to small retirement savings. They own partial interests in family homes or businesses. From their perspective, those accounts are separate from their American life. But under U.S. law, they are absolutely not separate. The government's response to this widespread unintentional non-compliance is not education. It's enforcement through visibility. By lowering thresholds specifically for these groups and embedding mandatory questions directly into standard tax forms, the government is removing the ability to say, "I didn't know." And by linking IRS, FinCEN, and USCIS data, they are making sure those answers are verified automatically. That's why understanding this now matters so much. Because once these systems are fully active, confusion is no longer treated gently. Preparation is the only real protection. And in just a moment, I'm going to show you exactly how these rules affect different groups of people in very different ways. Starting with seniors, who assume this doesn't apply to them at all. Before we go any further, I want to pause for just a moment. If what you're hearing right now is new to you, or if it's making you realize you might need to take a closer look at your own situation, please take 1 second to like this video. Not for the algorithm, but because the more people who see this, the more seniors and immigrants can learn about these changes before they accidentally put themselves in serious trouble. These rules are complicated, and the government is not explaining them in a way most people can understand. A simple like helps this information reach the people who need it most. Thank you. Now let's talk about how these new rules affect different groups of people, because the impact is not the same for everyone. And this is where a lot of dangerous assumptions come into play. If you are over the age of 60 and you were born in the United States, you might be thinking, this doesn't really apply to me. I'm not an immigrant. I've been a citizen my whole life. That assumption could get you into real trouble. Under the new system, age alone is enough to trigger enhanced reporting requirements. Any person over 60 who has any foreign financial connection will now face much more detailed questions on their annual tax return. If you receive a small pension from another country, if you worked overseas at any point in your life, if you maintain a bank account abroad for travel or family reasons, or if you have any ownership interest in foreign property or investments, you are now firmly on the reporting radar. What's changed is not just whether you have to answer these questions, but how detailed those answers must be. The IRS is no longer treating foreign assets as something only wealthy people need to worry about. Under the new rules, even a dormant account with just a few $1,000s in it can trigger reporting requirements if you are over 60. An account you only use once a year still counts. A joint account you share with siblings or aging parents still counts if you have access to it. The underlying assumption of the new system is simple and strict. If any foreign financial connection exists, it must be reported completely and accurately. The system is designed to assume nothing and verify everything. That means guessing, skipping questions, or thinking this probably doesn't matter is no longer safe. For many seniors, this is especially unsettling because these accounts often feel like part of a past life, something you set up decades ago and barely think about anymore. But the system doesn't care how emotionally distant the account feels. It only cares that it exists and that it meets the reporting criteria. And in the next section, we're going to talk about a group that faces even higher stakes under these rules, because for them, a financial reporting mistake can directly impact their right to stay in the United States. If you are a green card holder, the stakes under these new rules are significantly higher, and this is where financial compliance and immigration status become tightly connected. As a lawful permanent resident, you are already required to follow the same tax and financial reporting rules as U.S. citizens. That has always been true. What's new is how closely those records are now being examined by immigration authorities. When a green card holder applies for U.S. citizenship, USCIS conducts a detailed review of their tax history as part of the good moral character requirement. Under the new real-time data sharing system, USCIS doesn't have to ask you for this information. They see it automatically. They can see whether you answered foreign account questions correctly on your tax returns. They can see whether required foreign account reports were filed. And they can see whether the information matches across different forms and agencies. Here's the part many people don't realize. Even if a failure to report was completely unintentional, it can still create serious problems. It doesn't automatically mean your citizenship application will be denied, but it can trigger delays, additional interviews, requests for documents, and referrals for further review. In more serious cases, repeated or significant reporting failures can be used as evidence that you do not meet the good moral character standard. That's why green card holders need to be especially careful under the 2026 rules. Waiting until you apply for citizenship to fix financial reporting mistakes is risky. By that point, USCIS may already be looking at unresolved issues. Being proactive now gives you control. Waiting gives the system control. Now, if you're a naturalized citizen, you might think this no longer applies to you. After all, you're fully American now. Unfortunately, that assumption is not correct. The new regulations specifically include naturalized citizens in the enhanced reporting group. The government's reasoning is straightforward. People who were not born in the United States are statistically more likely to maintain long-term financial connections to other countries, even decades after becoming citizens. So even though you have the same legal rights and responsibilities as any other U.S. citizen, you are still subject to the lower reporting thresholds and increased scrutiny if you were born abroad. That surprises a lot of people, and it's one of the reasons so many naturalized citizens are caught off guard by these changes. And finally, if you are in the United States on a work visa, student visa, or other long-term temporary status, these rules can matter just as much. If you meet the substantial presence test for U.S. tax purposes, you are required to file U.S. tax returns and comply with foreign account reporting rules. For people who hope to apply for green cards or citizenship in the future, your tax compliance history follows you. Problems now can resurface years later when you least expect them. So whether you are a green card holder, a naturalized citizen, or a long-term visa holder, the message is the same. Financial compliance is no longer just about taxes. It's about your future in the United States. And next, I'm going to show you exactly what you can do starting today to protect yourself before these rules fully take effect. Now let's shift from risk to control, because this is the part that actually protects you. Instead of worrying about what might happen, the smartest thing you can do is take a few practical steps right now while you still have time. This is your action plan, and the good news is it's far more manageable than most people expect. Step number 1 is to create a complete inventory of every foreign financial connection you have. And when I say complete, I mean everything, even the things that feel small or unimportant. Sit down with a piece of paper or open a document and start listing every foreign bank account you've ever had access to. Include accounts that are mostly empty, accounts you rarely use, and accounts you opened decades ago and forgot about. Write down any foreign retirement accounts or pension funds, even if you are not currently receiving payments. Include life insurance policies issued by foreign companies if they have any cash value. List any foreign investment or brokerage accounts. And don't forget ownership interests in foreign property or businesses, even if you only own a small percentage or the property doesn't generate income right now. For each item, note the name of the financial institution, the country where it's located, the approximate value or balance, and whether the account is in your name alone or jointly held with someone else. If you have old statements or documents, gather them and keep them together. This single step prevents more problems than almost anything else because most enforcement cases start with missing or incomplete information. Step number 2 is to review your past FBAR filing history immediately. The SBAR, or Foreign Bank Account Report, has been around for years. If the combined value of all your foreign financial accounts exceeded $10,000 at any point during the year, you were required to file one electronically with FinCEN by April 15th of the following year. Here's the reality. Millions of seniors and immigrants never filed FBARs simply because they didn't know the requirement existed. If you're realizing right now that you should have been filing FBARs in the past but didn't, do not panic, but also do not ignore it. The IRS and FinCEN offer streamlined filing procedures that allow people to correct past mistakes with reduced penalties if the failure was not intentional. The absolute worst thing you can do is recognize a problem and hope it goes away on its own. Under the new data sharing system, unreported accounts are far more likely to be discovered. Taking action voluntarily before the government contacts you puts you in a much stronger position and can save you from massive penalties later. And next, I'm going to show you how to prepare for the new 2026 reporting requirements themselves, so you're not scrambling at the last minute when these rules officially take effect. Step number 3 is to start preparing now for the new 2026 reporting requirements, especially if you believe your foreign financial assets might exceed the lower thresholds. Because once those thresholds drop, many people who have never had to file detailed foreign account reports before will suddenly be required to do so. Waiting until tax season in 2027 will make this far more stressful than it needs to be. Begin gathering documentation early. This means collecting bank statements, account balance confirmations, and records showing the highest value of each account during the year. In many cases, you'll need to contact foreign banks or financial institutions to obtain older statements or official balance letters. That process can take weeks or even months, especially if the institution is overseas or if language barriers are involved. Starting now gives you time to do this calmly and correctly. You'll also need to convert foreign currency amounts into US dollars using appropriate exchange rates for the relevant dates. This sounds simple, but it's one of the most common places people make mistakes. Using the wrong date or the wrong rate can cause reporting inconsistencies that trigger questions later. Keeping clear records of how you calculated these amounts is just as important as the numbers themselves. Step number 4 is to make absolutely sure you are correctly reporting all foreign income. This is especially important for seniors who receive pensions, annuities, or Social Security type payments from other countries. Many people assume that if income is taxed abroad, it doesn't need to be reported in the United States. That assumption is usually wrong. U.S. tax law requires you to report your worldwide income, even if another country has already taxed it. Some countries have tax treaties with the United States that can reduce or eliminate double taxation, but those treaties do not remove the reporting requirement. You must still disclose the income in order to claim treaty benefits. Under the new rules, tax returns will include specific mandatory questions about foreign pensions and income sources. Leaving those questions blank or answering them incorrectly can now trigger automatic notices. Step number 5 is something many people underestimate, but it can protect you more than almost anything else. Keep organized, detailed records of everything. Save copies of your tax returns, FBARs, and any other foreign account reports you file. Keep bank statements, balance confirmations, and currency conversion calculations together in one secure place. For green card holders and anyone planning to apply for U.S. citizenship, good record keeping is critical. USCIS may ask you to prove that you complied with all tax and financial reporting requirements. If you can easily produce clear, organized documentation, the process is usually straightforward. If you can't, even simple questions can turn into major delays. Many cases are delayed not because someone did something wrong, but because they can't prove they did things right. And in the next section, I'm going to share a real story that shows exactly what can happen when people are prepared for changes like this, and why taking action now can spare you from an experience you never want to have. To really understand why all of this matters, let me tell you about someone I helped. This is a real situation, and I'm sharing it so you can see exactly how these rules play out in real life. Maria was 72 years old. She immigrated to the United States from the Philippines nearly 30 years ago, became a permanent resident, worked hard her entire life, and retired on a very modest Social Security income. Back in the Philippines, she kept a small savings account with about $8,000 in it. She used it once a year when she visited family and to help pay for medical care for her elderly mother. My name is Fernando. This is U.S. Policy Brief. Thank you so much for taking the time to watch and educate yourself. I'm here to help you stay informed, stay prepared, and stay protected. Take care of yourself, take care of your family, and I'll see you in the next one.